Hello, I'm Robert Wareham from the Law Center in Douglas County, Colorado. Recently, the General Assembly passed and the governor signed House Bill 19-1177. It's an act to create an extreme risk protection order directed at confiscating firearms from people who are deemed by the court to pose a significant risk. There's been a lot of misinformation about this law, some of it by the proponents of the law, others by the opponents of the law. What we're going to do in these series of videos is try and break down this new law, which takes effect on January 1st, 2020, so that you truly understand what the significance of this law is. This law is a law that proposes to deprive a person of possessing firearms if they are found to pose a significant risk to themselves or others. And the first thing we want to look at is just who can bring a petition for an extreme risk protection order. And I'm reading directly from the bill itself right now. The first classification is a family or household member, and that is defined as a person related by blood, marriage, or adoption to the respondent. A person who has a child in common with the respondent, whether or not they were married. A person who regularly resides or regularly resided with the respondent in the last 6 months. So there we're talking about a roommate or even a friend that you allowed to stay in your home for several months. A domestic partner of the respondent. A person who has a biological or legal parent-child relationship with the respondent, including step-parents and stepchildren and grandparents and grandchildren. A person who's acting as the respondent's legal guardian. And then there's sort of a catch-all. It says a person in any other relationship described in section 18.6, 800.3 sub 2 with respondent. So if we go and we pull up that section of the law and we look at it, we say that it's anyone who's been in an intimate relationship with the respondent being the person that the extreme risk protection order is directed at. Well, intimate relationship is defined as a relationship between spouses, former spouses, past or present unmarried couples, or persons who are both the parents of the same child, regardless of whether the persons have been married or have lived together at any time. Evidence of a sexual relationship is not necessary to establish the existence of an intimate relationship. That's a citation from People v. Disher, 224 Pacific 3rd, 254. It says a sexual relationship may be an indicator, but never a necessary condition of an intimate relationship for purposes of the Colorado domestic violence statute. So you could just be in a dating relationship with someone and they could decide, I think this person is unstable. So that's probably the biggest threat in this new statute that is coming along that has just been signed by the governor, is the broad scope of people who can bring this accusation. Now, what was noticeably missing in these definitions of people who can bring a petition for an extreme risk protection order? Well, obviously anyone with any mental health training whatsoever. There's no requirement that there be a psychologist or psychiatrist in the loop. There's no requirement that there be an evaluation in the loop. We are allowing people to infringe upon a fundamental liberty right based upon the fears of common lay people who have no training in mental health. Coming up next, I'm going to cover the process that'll be involved for a petitioner to seek an extreme risk protection order.